Good afternoon, everybody. Welcome to the Bold Inventor Show. I'm your host, JD Houvener, owner and founder here at Bold Patents Law Firm. And it's a pleasure to be with you, inventors, entrepreneurs, business owners, or just everyday people out there interested and curious about what this attorney is talking about on this live broadcast. We're here every week, every Wednesday at 1:30 Pacific time, and we go anywhere from a half hour to an hour, and we welcome you to our live audience. So anyway, any questions you've got, we're on Twitter, actually I should say, YouTube and LinkedIn today. So if you've got any questions, this is the time to ask. Throughout our broadcast, I'll try to prioritize any questions that come in from our live audience. As a disclaimer, I've got one quick little line to put in here. As an attorney, I've got to have some legal notice here. By nature of the broadcast today, there's no attorney-client privilege, and you are not necessarily, by virtue of joining this, a client of Bold Patents Law Firm. And so anything you say or hear is not going to be confidential. So if you do have anything you want to discuss with us confidentially, maybe this is the time you want to move forward with that invention or have a brand or a trademark you'd like to present and have a discussion about, I encourage you to have a confidential discussion with us. And you can schedule a free discovery call at that link right there, our weekly live link. And again, for those that may have missed it, I'm JD Houvener, owner, founder here at Bold Patents Law Firm, and I'm a patent attorney. I'm usually accompanied by my co-host, Matt Kulseth, who's out playing. I believe this summer he's got a lot going on up at his cabin in northern Minnesota. So wish him well. We'll catch him next week. And again, just a quick reminder for those that are tuning in, so we have a couple of live viewers. We'll take live questions throughout the program. I'll see if I can prioritize those beyond those that have come in over the week. So welcome. If you're watching this after the fact, again, you can catch us every Wednesday at 1:30 Pacific. We're here every week. Okay, we've got a bunch of questions that came in over the week, and I'm only going to swing away at the patent ones. I don't think I'm going to touch the trademark ones. I'll leave those for Matt when he gets back. And most of these questions have come from our Reddit pool, from the patent page on Reddit, which is awesome. I'll start with a really simple question. This one came in a week ago. And it comes up every once in a while. I think I do have a blog article about it, but it's about food, right? And summer barbecue, we think about food. It's a really important part of sort of the season, with a lot of different seasons, of course. But can food be patented? Can you get a patent on a food item? Well, and the legal technical answer is yes. Yes, you can. Can you? It's very, very, very unlikely because food has been around since the beginning of time, right? Animals, humans have been eating food, mixing different ingredients and recipes. The question is what you have come up with truly novel, right? The two big requirements that'll be hard is it the first of its kind. If you come up with a new food item, a new ingredients list, a new final product that's never been done before, that's a huge barrier to get over. And then probably even bigger barrier is it non-obvious? Okay, has there ever been any publication, any type of a teaching or cookbook or mention in what's published in the world of all of food and preparation of culinary festivities, any way to combine the elements that you have, even though it's never been done before? For example, you could put in any type of a sweetener, even though no one's ever used, let's say, I don't know, stevia combined with, xylitol, okay, along with, putting it inside a fruit, dragon fruit, trying to get creative here. So that final product, dragon fruit, you got stevia, which is like a monk fruit with xylitol, and you're trying to mix that all together. Well, if there has been any publication about, well, you could certainly mix fruit and maybe even dry the fruit and include any type of sweetener available, that publication would prevent you from getting a patent, even though no one's ever put xylitol, right, which is, I believe, is a chemically derived sweetener. Hope that helps give you some example, or that example gives a little bit of color as to how challenging it can be to get a patent on it. Now, not to say you shouldn't try if you've got something really unique and you've been in the industry for a while and you've been able to combine methods in terms of heating, cooling, injection, however you're exactly positioning the food. Maybe it's got some design elements. That's where you could get toward more patentability if it's not just the actual substance, but it's what it looks like. in terms of a cake, or you've seen really popular TV shows, these cake decorating or bakers, perhaps. Thank you for that question. We'll probably do 3 more. And again, I welcome any live questions. If you have anything on your mind, no question too simple, don't worry. It'll be fun. So here, this one came in again from our Reddit community, and it's about someone who's inventing on the job, which is a really important category. So what if on the job I make something and the company just decides to patent it? They're just writing the patent now, and it should publish in November. What happens if I leave the firm, okay, in September before it publishes? Do I still get my name on the patent? Great question. Well, the answer to that question is yes. As the inventor, it is actually legally required for your name to be listed on the patent. Usually, and I'll say 99% of the time, especially if you're working for a larger company, when you sign on to become an employee, as part of that contract you sign, you've got the obligation to assign, right? To give your rights to the company if what you created was on the job. And it sounds like in this case, that's what it was. You're working, maybe your job as an engineer or a designer. You come up with a new design, a new invention in furtherance of what you're doing for your position. That's going to belong to the company. So traditionally, the inventors do have rights to fully exploit, right? Make, use, sell, import those products. But by nature of that employment agreement, you are giving up those rights to the employer. So take a look. Maybe there's a chance that there's not that clause in your employment agreement, and you might be able to have some rights. But odds are it's going to belong to the company. But your name will be on it, which is awesome, and I think that'll be there. So you can definitely use that as a avenue for resume building, perhaps, or showcase something that's been published that you worked hard on. So there's additional benefit to having that, even if you don't have the actual rights to exploit or make money from it. You've got that published document that's irrefutable, that you were the one that came up with this, maybe one of a few others that came up with this concept. Okay. All right. So next question here. There's sort of some introductory part of this question. It looks like it's related to provisional patent applications, multi-part. So I have an idea and I plan to submit a provisional application for. I work with a patent attorney. It's for clothing design. A quick search finds nothing in particular in patents or patent applications. However, the space I'm in is growing. So I'm worried there are unpublished applications out there. I think we actually got to this question last week, so I apologize. That's a repeat. Okay. I'll get one that's a truly new backup question. Okay. I'm looking to get an idea registered, but I already think there are plenty of patents out there on this. I also know my solution is unique. What would be the cost of a patent application or even a provisional one? Okay. It's great. Very good. Well, patents don't get registered. Patents get granted. You're granted the rights of a bundle of 4 rights to make, use, and sell the invention. Registration is on the trademark side. So trademarks get registered. And that's the difference just in terms of nomenclature, right? Legal jargon. It's not that big of a deal in terms of answering this question, which is about cost. And so cost, there's kind of different things to talk about here. There's cost in terms of money, and there's cost in terms of your time as the inventor. And so what I want to talk about is your time as the inventor first. And I think I always recommend this, and that's what I talk about in this book behind me, is ideas are dime a dozen, unfortunately. And I think it's too common that you want to just move forward with an idea before doing some of that diligence and research up front. So that is your time. And that's a cost, right? Your time is valuable. But I think it's something you should do before you even hire an attorney, is do some diligence and research on your own. Find out maybe 2 to 3 hours, perhaps, is a decent amount of time on search engines, publicly available resources, libraries, that type of thing, just to go look and see if anyone has ever done this before. Look into different industries, especially if what you've created, what you've come up with, is outside of what you do on a day-to-day basis. So that's the upfront cost. The next step is before you file, hire a professional team to search. Okay, so you've done your own diligence. Now you're ready to actually hire someone to do a professional search. This is giant. Don't just file something without even looking, right? That could be thousands of dollars, sometimes $10,000 or more, investing in a patent application without looking first. And so you've done that initial look on your own. Now it's time to hire a professional. Go see what else is out there, what's been published. Have a professional go and look at the USPTO, look at the patent applications that are published here in the US and, of course, in foreign countries as well, to see what an examiner would look at, right? Put yourself in the shoes of the examiner to know in advance what are they going to be looking at? What might they find? So you know precisely whether you'll be able to get a patent at all, and hopefully get a sense as to what the scope of rights will be. So a solid patent search, can be done for $1,000, a couple grand, but what you really are looking for is not just a huge list of results. Is you want an attorney that's expert advice to give you an opinion on which are the most relevant results in that search. And then beyond that, what do they recommend? Should you file a patent application or not? That's the money line, right? That's what you're looking for. That's what you pay our firm. We charge $3,500 for that opinion. And only if it looks good, only if it's a true green light, we think there's room and a big enough scope, do we then recommend you file an application, whether it be provisional or non-provisional. And that can be around $10,000, right? Give or take a few grand, depending on the complexity. So it's a small jump before a big leap. So that's why I always recommend looking at costs from that perspective of your own time, as well as what fees will be paid to the law firm. All right, thanks for that question. We'll do one more, then get to our interview. We've got Arshad Hisham waiting backstage from InGen Dynamics. So hang in there for just another question here before we get to Arshad. All right, so this is from Quora, Quora. We've got a database of questions that have come in. So many here. I'm not going to get to them. This will be one I'll just pull out from the top. It's straightforward enough. And I think it's a question that comes up a lot, especially when I started talking about cost. So should I try to file my own US patent without the help of a patent attorney? Of course not. I'm an attorney. That's my job. I'm going to tell you to hire a patent attorney. I'm a little biased. But I guess the real answer is it depends. Okay. If you do not have enough money, to hire a patent attorney, there are maybe a couple other options that might be better than nothing, better than doing it on your own. There's a special role called a patent agent. Patent agent is someone who has a technical degree, usually a Bachelor of Science or more, master's or doctorate degree, and they have passed the patent bar. They have not yet gone to law school, but they have passed a special bar that allows this technical, scientific, engineering type individual represent inventors before the patent office. And so without being an attorney, you can be a patent agent. Typically, those agents, not always, are less expensive. And so you can look at them as an option to be, hey, this is someone who knows how to write an application, may not be able to offer you a legal opinion or help you with infringement concerns down the road, but at least it can help you, write a better application. They're familiar with the formatting and all the loops and how to deal with examiners. So look at that first. I guess the next step might be, there are resources to, hey, this book behind me, Bold Ideas, The Inventor's Guide to Patents. We've got our YouTube channel. Check out @BoldPatents. Maybe you're watching right now. Free resources to go learn before you file your own. So that way you're informed, as much as you can. And it happens a lot. I'll just say it where we end up we're helping inventors that have filed their own and they've gotten that horrible, what's called an office action from an examiner. And now they've got to come back, respond to it in a professional way, and they need help. So we end up looking at it and say, oh gosh, we may need to actually refile your application, fix some things up, and get your application over the finish line. It's not the worst thing in the world. Yes, ideally, we would have been the one to help you prepare the application out of the gate. But I understand cost and resources and time is not always in your favor. So the answer to the question is no. You should try to hire a patent attorney if possible. If you can't afford it, try a patent agent. Before filing on your own blindly, go get educated and informed first. So I hope it helps with that question. All right, let's bring on our guest. We've waited long enough. Thank you for waiting. Arshad Hisham, welcome to the show.
Hi, thank you. Pleasure to be here. Hi.
Wonderful. Well, I appreciate your time and being willing to come on and talk with us. So you're the founder of InGen Dynamics. Am I saying that right?
That's right. That's right.
Okay, perfect. Well, I would love to hear about your company, of course, and then as an inventor, I want to hear about maybe a specific invention that you'd like to talk about in some detail on our show. So maybe let's go back and talk about the founding of your company.
Sure. Uh, my name is Arshad. I'm a serial entrepreneur. This is actually my fifth company. So I've been doing a couple of other companies in different domains, and my companies have increased in complexity. So I think it started out with software companies, enterprise software, and going all the way to robotics, AI, and automation. So we started out in 2015. It was very early days. AI was not the in thing, not the buzzword as it is now in 2015. And so we were into AI, automation, robotics when it was uncool, so to say. It was pretty
Right.
early for us to be there. And we were fortunate to get a lot of traction. We had a video that went viral. We got picked up by Discovery Channel and Popular Science very early on our products that we were '89. And I think it's been an interesting journey. So our key goal is to improve quality of life for humans with affordable, intuitive, and practical AI automation robotics. And these are very important qualifiers where most of the AI automation robotics companies fail, right? So these are like what we're trying to attempt. And I am an engineer. I'm still an engineer, and I think I started my career with IBM Software Labs. Did some work in robotics way back in college. I'm giving away my age. It was like 25 years back,
Mhm.
and I did make some cool robots that played soccer, and wrote a paper on a coherent back propagation network, which is one of the predecessor to the current AI networks. This was in '97. So I think I did work in. I had a couple of research papers in AI very long back. So yeah, I started this company, and it's been a fantastic journey. We have a range of products for hospitality, healthcare, retail, surveillance, and a couple of interesting reports which are relevant to our company is one from McKinsey and OECD, which says that 95% of the jobs in the next 5 years would have at least 70% containing elements of AI automation robotics. So it essentially means that the way jobs are defined are going to change drastically. And I think a lot of the tools and products are going to play an important part in this journey coming in. And I think our company is in the middle of it, and it's exciting times.
What was that? What was that stat again? 90% of companies will have AI robotics.
Yeah, so around 95% of all
Okay.
jobs would have tasks, and 70% of the tasks would have components of AI automation robotics. So I
Wow.
think the way jobs are defined are going to change drastically in the next 5 years. And people are going to learn how to use this new tool. This is like, think of like the pre-computer and post-computer. So I think a lot of the things coming out are the new computers that every job is going to need, right? That's a better way of looking at it. So I
Yeah.
think, and this is kind of and this is coming very fast, and you can see some of the magic with AI videos. Like a couple of years back, you had the strange Will Smith video. I don't know if you saw the one with the spaghetti.
No, I didn't
There's
see
a
that
very
one.
yeah, there's a very strange video. It looks very odd. It looks very goofy, very AI generated. But within a year, it's so good that it actually looks like shot in a Hollywood studio with all of the physics. So that's the speed at which these things are developing, right?
Mm-hmm.
So that's actually going to accelerate in the next 4 years. And I am pretty certain that it's not going to take away jobs. I think it's going to create new jobs. It's going to change the way a lot of jobs are done, and I think it's going to increase human productivity. And again, I'm an optimist. I'm an entrepreneur,
Yeah.
so that's my 2 cents on the whole AI and robots taking away jobs, right? So I think that's where
Yeah.
I think this is headed.
We're gonna be all right. We're all gonna have at least somewhere to
Absolutely.
be employed. I wanted to show so you've got a website. You're doing some marketing. You're selling, right? So walk me
Yes.
through what you're doing how do you work with customers?
Sure. So I think we have, this is a restaurant robots. We have a collage of all our products. So there's a restaurant runner, there's an
Right,
origami AI platform, there's a tabletop robot. So we kind of have different products in different stages of development. Some are in R&D, some have hit the market, some have hit early revenue, and some have hit good revenue. We also have an education product. So we kind of started out a couple of engineering degrees based on our products. And
right,
we're actually skilling people as well. So when people come in, if they need a surveillance product, we actually look at the current surveillance system they're having in their mall, in their business, and we look at the pain points, and we give the AI-enabled layer to make it smarter and better. So this is what we do with the surveillance, and these are like pretty cool. It kind of compares posture to determine if two people are fighting. So I think it can detect if people are fighting from your feeds. It's smart enough to bring up something called a virtual camera. So if you have hundreds of cameras, your main monitor will have only like 9 or 6 feeds where it only shows the relevant events. So it's very smart. And it
okay,
can be on top of things. So and we onboard them and come in. And then we have the restaurant robots, which does point-to-point delivery. We have the tabletop elderly care unit, which again we're doing several pilots. And I think we have got a fairly good revenue pipeline. We have an $80 million revenue pipeline. So I think there's a lot of
yeah,
work to be done.
for sure. Well, yeah, that's huge. Well, I mean, and when you said that multiple camera angle thing, my mind went to, I always wonder how the producers at, sports events, right? Football, for example, right? With all the different camera angles, how do they know which one to go with? And especially for replays, I think it's incredible probably how that happens, but perhaps AI could do even better job, with things like that.
Absolutely, absolutely. I think there's been some fascinating uh, mishaps and goof ups, with players' heads being, detected to be a ball and stuff like that. So I think there's a
I see.
lot of
Yeah, sure.
yeah,
Well, yeah. The example you just gave about the Will Smith, I mean, how far can things improve in a
yes,
year's time?
yes.
I think it's wonderful. So, well, let's get a little bit more granular with respect to patents and all of this AI, and perhaps maybe just pick one that may come to mind you'd like to talk about. And I think it's really relevant. One that I'd love to get to is I get this question once in a while where it's like, you know what, our industry is moving so fast, forget about patents. Do you worry about that? Do you think how does that play into your decision making as to investing in IP?
Yeah, I think patents are very important, and I think it's kind of a bare minimum. You need to have it protected. I don't think you can build a company on patent alone,
Right.
but I think it would be very foolish to build a lot of stuff and don't have patents to protect it, right? So I think that's a right balance. And I think for us, we have design patents for our tabletop robots, which contains the interlocking mechanism. It's a modular unit. It's like a bionic lock. And I think we spend a lot of time on design, and design is interaction design is not the way it looks, it's the way it works and feels, right? So I think there's a lot of components that we've designed, which I feel is very unique. And when people try to copy it, I think we always hold that design patent. And I think, there are things that uh, makes it harder for people to kind of copy and and get out. But I think this is kind of an important thing people needs to be aware of is that patents are like moats. I think it's a line of defense if you're getting attacked on some of these points, but it is not on its own. You can't build a company around it until and unless your end goal is to sell 100 patents to Apple for
Right.
HP or for
Yeah.
IBM.
So
That's a different strategy, right? Until
sure.
unless you have that, then you need to look at and you need to figure out, and that's why I think you need to get expert help because it's so tough for the inventor. He'll be in his own world. He'll be looking at what he's doing from his own perspective. You need outside help so you can have a fresh perspective, get inputs from experts. It's very important to get help.
Wonderful. And by the way, I did not talk with Arshad before that. I did not pay him to say that patents were important. I love that. I also want to talk to a couple of things there. I want to definitely talk about design versus utility patents. But before I go there, you mentioned defense. So have you had to fend off or enforce your patent rights at all at this point for InGen?
We had to send a couple of cease and desist.
Okay.
Okay,
Yeah.
not an outright. We just had to warn some people off, and I think it did help.
Good.
We hold.
It scared them off. Enough. There was no court, no filings,
Yeah.
no
Yes.
claims made.
Yes.
Okay.
Yes. So we had a couple of them, and our product had such good aesthetics that we were picked up by Walt Disney to be showcased in one of the. So I think we did have a lot of copycats coming out with similar colors, similar eyes, similar curves, right? It did
Right.
crop up a lot. So the design pattern was kind of relevant at that time to kind of protect what we're building.
Yeah.
So we did, yeah. And I feel issuing a cease and desist and having a paper trail of something concrete behind you fends off 95% of the people who are trying to kind of get in your way, right? So
Sure.
this is, I think, the right way to use it.
Yeah, it's sort of the threat of what could be future litigation.
Yeah.
And so the focus on design is interesting. I think it's fantastic. You bring it up. I think especially with some of these really big names, you mentioned Disney, where that's what people see. Is there a strategy behind the scenes where you're actually keeping trade secrets behind the enclosures instead of going after utility patents? And for those that don't know, real quickly, a utility patent can be much broader in terms of its protection, covering the functionality of what something does, but can be certainly more difficult and expensive to acquire a broad set. Whereas design patents, as Arshad explained, covers just the aesthetics and the feel, the form, and the fit, and the shape, of course. But it really stops there. So tell us, is there some other strategy at play here, or more of kind of a hybrid cost savings in a way too?
Yeah, I think it's also a function of the way we've done development. And I think we had several provisional patents filed, which we had several. So I think, and when, as you know, with provisional patents, when you change direction, you kind of redo and, it kind of goes in a different direction, right? So we did have that. And we were trying to identify what is the best utility pattern. So I think there is a whole it's not that we do have a plan. We actually have a patent plan. So we do have a patent plan of how we can do and roll the whole thing out. And even had, I think it's called the patent highway, where you can take it internationally to a UK patent office and everything, right? How you can take it from the US, get protection, and take it in the UK, which all countries you want to go. What are the different rights you're having? So we did do pretty good deep study on it. So we do have a plan. So we do have provisional patents and we do have utility patents coming down the line. But one of the reasons we consciously are not aggressively, the provisional patent, again, you're the expert here, would probably give a 3-year protection and I think there is a recent change from first to file to something else from the USPT office. I think it's very recent.
Oh yeah, no, that's almost 10 years ago. A lot changed. So it used to be first to invent, and there were all these battles about who invented it first with documents proving. Now it's whoever files first. So that's how the rest of the world does it. With respect to international applications, they're on the utility side. You can file two types of domestic apps here in the US, either provisional, which will provide you just 1 year of time, and then a non-provisional, which is the formal version. That's what must be filed within that year on the utility side. And then on the utility side, going international, it's called the Patent Cooperation Treaty, PCT. And that's a way to sort of save money in terms of not having every country do their own search. One search is performed on behalf of the whole world, and then each country recognizes that. And there's a big benefit there. On the design side, quickly, it's called the Hague Agreement, HAGUE, also under the WIPO, World Intellectual Property Organization. In a similar way, industrial designs, they're called, can be registered in various countries in the same way, and it can save a lot of time and money, especially if you wait, and see what the U.S. examiner says. If they give it a thumbs up, it's almost a rubber stamp, approval from the other countries.
Sure. So thanks for that. And I think, I just want to kind of we do have a plan. So I think it's called the patent prosecution highway. I'm not sure what it's called.
Yeah.
That is how it's kind of
Nice. There you go.
Yeah.
Perfect.
Yeah.
That's a good way to go. Well, you've got a good plan then, it sounds like, and competent counsel as well. For you to be able to list that off, that tells me you've been listening. You've got good counsel. That's great.
Sure.
But it sounds like you've not yet had to go into federal court to defend any patents yet, which is good. But you've gotten as far as sending letters, which is also very good. I guess in the next couple minutes here, I'd like to talk about the future of your company and where things are going to go for you and InGen in the next, say, just 2 years, not looking too far ahead. What do you see happening with products you're developing, the work you're selling? What are some things that you'd like to see come to fruition?
Sure. I think there is a lot of our products that getting a lot of traction. So we're going to see more market penetration in all these new use cases we are developing for sure.
Okay.
We have new form factors coming out, which you have already seen. We do have humanoids coming down the line from our company.
Yeah.
So we do have humanoids and autonomous rovers, which are coming out outdoors. So this is another thing that we're developing.
That's cool. On the humanoid side, do you have a product that we could show off or give a link to? Anything yet?
Not yet. Not yet. It's still under development. So we do have the brain. We call it the Origami AI platform.
Okay.
So we've been developing the brain from 2015. So it's the same brain that's going to power all of products, right? So the brain is under development, and then we get into the mechanical side and
that's
build out
the Origami AI.
That's right. That's right. Yeah.
Very interesting. So a lot of different functionality. My goodness. Wow.
Yes. So that's why it's called the Origami AI, because you can repurpose it to different form factors, just like origami. So you can make different products out of it.
Yeah. I haven't heard of this. Is this a term you've coined, or is this a third party, Magnus?
No, this is our AI automation robotics blockchain. This is for the robots and products to communicate through blockchain. So we do have a blockchain component which we build. Right?
Wow.
So
very big. So excellent. Well, for those that I know we didn't get any live questions today, but those that may be watching, maybe that are way early in their entrepreneur adventure, maybe where you were 20, 25 years ago, any lessons learned, anything you'd like to pass along to, individuals, engineers that are curious about, gosh, how do I get started in, building my own company? Any kind of words of the wisdom there?
Sure. I think 2 points that will come to my mind. The first one is that I think being resilient is way, way more important than being smart or intelligent or hardworking, right?
Say again, talking more?
You need to be resilient. You need to you'll get beaten down very frequently. You need to stand up and fight again.
There we go.
Again, right?
Okay.
So that's 10x more important than anything else.
Just grow some thick skin, right? Get used to no, and keep on going. Persistence.
Absolutely.
Got it. Okay.
Absolutely. So that's kind of way at the top. And the second thing is that the people that you recruit hire for attitude, not skill. So I think this is again another hard lesson. I think hire for attitude, who can gel with your culture. So these are the 2 things that I think many new entrepreneurs overlook because they come out fresh with a lot of new ideas and everything, and they overlook this. So this is what I would like to highlight for anybody starting out. And the third is hang in there. It's a long journey, but it's worth it. The journey is a reward.
Yes. That's great. Well, wonderful. I'm honored that you want to come on our show and share with us some insight there. Hopefully those listening were able to pick up a few of just the gold nuggets you shared. So we'll wrap up our show, and I just wanted to remind our guests that we've got our next show coming up next week, Wednesday at 1:30. If you have any questions for me, you've got our information here on the YouTube channel. Arshad, if anyone has questions for you, are you comfortable if I give your email address away?
Absolutely.
Okay. Well, I'll put that here. So feel free to contact Arshad. We've got Arshad.Hisham at InGenDynamics.com. Hopefully I got that spelled right.
Yes.
All right. Excellent. Well, thanks again. And on behalf of Bold Patents, myself, wish you guys a great rest of your day. Go big, go bold.
Thank you.